Different sources of the British Constitution. Introduction. The British Constitution is not found in one document. It consists of different elements that are scattered. The British Constitution is unique in nature and is constantly growing. It came into existence with the passage of time. It can only be understood by reference to a long series of acts, traditions, and judicial decisions. Sources of the British Constitution. Following are the sources of the British Constitution. A. Constitutional landmarks. A constitutional landmark is a combination of documents, charters, and laws. This came into existence in the form of agreements, contracts, treaties, or recognition of rules by Parliament. For example, the Magna Carta of 1215, Petition of Rights of 1628, Bill of Rights of 1789, Act of Settlement of 1701, and Parliament Act of 1911. B. Statutes. According to the requirements of the people and demands of the government, the UK Parliament formulated the law, which not only played a vital role in the source of the Constitution but also delivered coordination among the institutions of government. The following are the important includes in the sources of the UK Constitution. 1. The Habeas Corpus Act, 1671. 2. The Municipal Corporation Act 1716. 3. The Reforms Act 1867. 4. The Judicature Act 1873. 5. The Representation of People Act 1918. 6. The Ministry of Crown Act 1937. C. Common law. Common law may be defined as those rules that are the product of a slow process of long historical growth and are based on customs and traditions. These principles are not set down in any statute or ordinance. The courts recognize these principles. The prerogatives of the Crown, the right to trial by jury, and the right to freedom of speech rest almost entirely on common law. D. Judicial decisions. Another source of the UK Constitution is to be found in judicial decisions. Judicial decisions are the judgments and interpretations of courts, which define the scope and limitations of the different charters, statutes, and common law. E. Conventions. A substantial portion of the UK Constitution is based on convention. These are not codified in any book of law. The courts do not enforce conventions, but these rules are recognized by the Constitution. F. Important conventions. Following are some of the important conventions. 1. The Crown has no power to veto a bill passed by both houses. 2. Parliament must be summoned once a year. 3. Prime Minister will be from the House of Commons. G. Opinions of jurists. The opinions of jurists are also an important source for the UK Constitution. The jurists express their opinions in consultation with customs, traditions, judicial decisions, and statutes. Some of the important books of different jurists are as follows. 1. Austin's Law and the Customs of the Constitution. 2. Dicey's Law of the Constitution. 3. Lord Halsbury's Commentary on the UK Constitution. H. Statutory rules made by various authorities. There are various authorities empowered to legislate under parliamentary acts, like universities and municipal bodies. The laws and rules made by these authorities are part of the UK Constitution.